Okay, I'm Alicia Chandler. I am IACP's Associate Director, and I want to thank everyone for joining our monthly webinar series. A little bit of housekeeping. If you're interested, you can use the CC button at the bottom of your screen to turn on English captions. Today's webinar is free to IACP members thanks to our generous sponsors at Divorce Force. Divorce Force is a marketing platform for divorce professionals, and they have generously offered IACP members a discount code of $300 off of their program by using IACP at checkout. We're going to play a short message from Divorce Force.
Divorce Force Pro is your smart marketing platform, providing all the necessary yet easy to use tools to help professionals connect with new clients and expand referral networks. Visit divorceforce.com today to learn more.
As most of you will know, IACP has been promoting collaborative practice for over 20 years with lawyers, mental health professionals, financial experts, and child specialist members in over 25 countries and on 5 continents. Our mission is to transform the way families resolve conflict around the world. And we welcome all collaborative professionals and consensual dispute resolution professionals to join IACP. They can visit collaborativepractice.com to learn more about membership benefits, including free training opportunities. Today, we'll be speaking with members from the IACP Standards and Ethics Committee who represent each discipline of a professional team. They'll discuss the differences that may arise in professional ethics relative to their roles. We have with us today Aline Lammers and Jeff Wasserman. Also presenting, you'll see Melissa Solkowski. She's a mental health professional and mediator from Erie, Pennsylvania. She's chair of the Standards and Ethics Committee. She's been an IACP board member since October of 2019 and an IACP member since 2011. Marta Alfonso is a lawyer and financial professional from Miami, Florida, and a member since 2013. Aline Lammers is a mental health professional and mediator from Vernon Hills, Illinois. She's been a member with IACP since 2012. And Jeff Wasserman is a lawyer in Boca Raton, Florida, and a member since 2016. Thank you all for joining us today. The webinar will last approximately 60 minutes with a Q&A at the end. So if you have any questions, please feel free to go ahead and enter those questions in the chat. And once we get to the Q&A session, we'll be happy to address those.
Welcome, everyone. We're very excited to spend time with you today and hope that you find the webinar worthwhile and engaging and informative for what you're looking for. So we're hoping that everyone received and had an opportunity to read the fact pattern. We're actually going to have that up on the screen for reference as we go through just some of the questions for the panelists. And certainly we'll have time at the end for some live Q&A, but we will kind of go through what we have thus far based on the fact pattern you received. Okay, so I'm going to ask Marta to kick us off. We are interested, Marta, when you have one of the parties that owns his or her own business, how do you normally handle that initial contact with that party?
Well, in my neutral role, under the Ethical Standards 3.5, it requires me to notify the team and the parties that I'm going to meet with one person separately. And as a practical matter, this issue would likely be raised up front in the pre-meetings before we would start, and there would have been a determination made as to whether I should approach him individually or not. So assuming that I had been given permission, then I would send out an email, contact him, copy everybody else in, and then conduct the initial discussions about the business.
Okay, thank you.
If I can add to that, before the process starts, everybody needs to sign the participation agreement. And in the participation agreement, there is going to be a provision for fair and full disclosure. And it's up to the attorney to explain to the client that when they speak with the financial neutral, that they are going to have to be fully candid with all of the information that they have concerning their business especially when it's a solely owned business as opposed to working for somebody and being a W-2 employee. So this would be something that would be discussed at the very, very beginning prior to the actual first team meeting when a participation agreement is signed.
So typically, unless the parties consent, I am not going to have that first meeting with the client until after the first meeting with the team, so that everybody is clear on what the role is, understanding that they want me involved in doing the appraisal and a discussion of what an appraisal for a business interest looks like.
Okay. Aline, I'm just curious, as the MHP, if you would be able to, based on the wife's concerns, provide any advice on whether or not she will have to provide child support, and if so, why or why not?
Okay, so I'm looking at various items in the ethics and standards, and the first one I'm looking at is 1.2D, which talks about the collaborative professional who respects the expertise and skill and experience of other members. So in that case, I would direct the client to talk to her attorney more in depth and kind of have a conversation about that. The next standard that I would look at in terms of this would be 2.4, and 2.4 basically talks about consideration of likelihood of reaching a resolution, and both of these would go hand in hand. Once she would talk to her attorney, then I would talk to her further about, realistic expectations, which is in 3.2B, having the realistic expectation working as a team with the attorney and of course with the other professionals on the team. But 2.4 would also be in there because we would have to assess her willingness in terms of how positional is she really. And once we provide more support, guidance, education, can we get her to a point to look at more of the needs and interests versus being so strongly positional as she is, basically stating in this particular comment. Then I'm looking at 3.2C, talking about what is the impact of this on her children if she really does refuse to look at anything in terms of child support. What does that mean to them, financially, obviously? And then there's also 3.2C. That was the care of the children. 3.4A and 3.4C would be two other areas that I would look at in terms of obviously informing the team that this is going on and talking about it with the team, and also looking at my own feelings, my own impact on the process. Those would all be, things that I, would look at during that conversation.
Okay. How about for yourself, Jeff, and Marta, feel free to chime in as well. As the other professionals on the team, how would you navigate that information that Aline would be bringing based on the wife's concerns about child support?
Well, from an attorney standpoint, I think this is more of a legal issue than it would be a mental health professional issue. And I would be a bit concerned about the mental health professional giving advice to the client concerning any of these issues. And as it relates to the question, and depending on what jurisdiction you happen to be in, you may or may not be able to waive child support. As an attorney in Florida, child support cannot be waived. However, there are certain factual situations where the parties have an equal income, they have the children an equal amount of the time, so the child support would essentially be 0-0, and each parent would have to support the children when they had them with them. But this would go back to 1.2 in the ethical standards, and we must comply with our own professional standards in giving advice to the clients. And we need to stay in our own lanes. Now, I normally would provide the financial neutral, the ability to work up the numbers as it relates to child support. and I'll turn it over to Martha at that point.
I mean, from my perspective, my role would be to at least have prepared the calculations to provide both spouses with the information of what child support amounts would look like, because if they are de minimis, then Jeff's position of each supports because they're equal is one thing. But in this situation, we're aware of the fact that part of the reason she didn't want the child support, or that she doesn't think the child support is correct, because she's saying her life isn't worth living after the divorce. So there are other mental health issues that are coming into play here that really have, in this situation, not much to do with the finances, but everything to do with what the law requires and how emotionally competent she is to make decisions, which is where I get into here, 3.8, how do we counsel clients? I to 3.3, is this really a good faith negotiation? Because is she well enough to be able to take this on? Are we looking at back to 2.4? Can we, really realize a reasonable resolution and a realistic one because of her situation? I have been in cases where the team has determined that there needs to be a timeout until the person that is emotionally, I'm going to use the word fragile, because that's what it comes across as, that she's not able to process the information effectively. And so therefore, does she need a timeout to get back on more of an even keel? And those are all things that we would probably discuss as a team outside of the client, team meeting.
And I
Well, that
pick up
really-
on, go ahead.
Well, I was just going to say that really speaks to our intention in creating this webinar, is really how do we, in these circumstances, support our clients, right? They're all, any family coming to us is our client. And so how do we integrate the different disciplines to support based on just this one identified need that we're talking about? Aline, yeah, sure, pick it up. I was interested in your thoughts on her saying it wasn't, her life wasn't worth living beyond this.
Right. And so that leads me into just a whole slew of these ethics and standards. The first one being 1.1 and 1.2a, basically that we each need to comply with our own professional conduct requirements applicable to our own profession, and also that the team will respect each other's expertise and skills in terms of dealing with things. Both of those are really important in a case like this, because this is a very complex situation. And then we're looking at 2.3. 2.3 basically says the effectiveness of participation in the process. Similar to what Marta was saying, can she really actively participate in the process, knowing that this is the case? We move into 3.1, which is the
Aline,
Yes.
Can I interrupt for a second? How would you present that in a pre-brief to the team? The fact that the wife has indicated to you that her life would not be worth living after the divorce if she had to pay child support. How would you go about presenting something like that so that the team would be able to put their arms around it and figure out where are we going?
Well, I would bring it to the team just that way, telling them this is what this client has told me. And I would add to that some of these other caveats in terms of the limitations of confidentiality. So when I first meet a client, this would be prior to even the first team meeting, I have them sign a consent form if they're willing to, if they have a mental health team, if they have a therapist, if they have a psychiatrist, if they're willing to sign a release, I get that signed. I also talk to them immediately upon the first conversation about what the limits to confidentiality are. And those limits include if somebody expresses anything, a homicidal, suicidal ideation, and in addition to that, if somebody's harming or abusing a child or an elderly person, I have a conversation with that immediately in the very first session, so that they understand that these are the limits of confidentiality in terms of keeping this within the team. Because of moral issues as well as ethical issues, I need to ensure safety for any client that is expressing thoughts of this type. And what does that mean? So again, if in this case, if she had signed a release of information, I would have contacted her and I would have talked to the team about this. I would have contacted her healthcare professionals. If she either did not have a team or refused to sign a release, I would tell her that if she feels this way, she would need to go for an evaluation to make sure that she is safe, that she will be okay. And lastly, if she refuses that, and if in fact I truly felt that she was in danger in terms of imminent harm, I would have to, and I would be required to call the police to do a well-being check on her. This case is not so clear because it's an if this happens, then this is how I feel. So it's not like she's saying, I feel like this right now, but perhaps I will. So I have to also think about, when it would be appropriate to call the police. Again, she has to be in clear and imminent danger for that to happen. And if in fact I had to do that, what does that do to my relationship working with her moving forward as a neutral? Does she feel that she can work with me anymore if I felt the obligation to do that? And let me also say that she would know all of this in advance. This would not be a surprise. This would not be something that just would happen to her. She would know these are the things that I need to do. And it's just kind of not a conversation to be had about it if I truly believe that she's in danger of harming herself. But then it becomes an issue of if she feels she can't work with me, or if for some reason I felt I couldn't work with her in terms of being in a neutral role, then we would have to look at some of the other ethics later on in the standards here about leaving a case, terminating a case. Either myself as a coach terminating my services, perhaps at her initiation, or perhaps the team is uncomfortable in terms of moving forward with this, unless or until there were more safety things kind of added into place to ensure her safety. So there would be all kinds of thoughts and things to think about in terms of this.
Aline, it reminds me of a case that I had. I was in the New York airport and I was on the phone with a client, a collaborative client, and the client communicated to me that the person was despondent. Okay, the person was at a point where they wanted to harm themselves. And here I am standing in this airport in a completely other place. And I'm thinking, what do I do? And so I said, if I call the other neutral, I don't know if the neutral, A, I can reach them, and B, if they're going to feel that they're in a position to address the issue completely. I said, the other thing I could do is call her lawyer and make sure that that lawyer's aware, she can contact her, she's local. So I was texting her lawyer while I was on the phone with her. Needless to say, the airplane left me because I wasn't going to leave the person off on the phone. And they went to her house, they took her in, and she was in treatment for 3 months. And that made a huge difference for her. And sometimes the things don't work out perfect because I didn't have time to notice the team, but I didn't know that I could get a hold of her lawyer. So then the lawyer, of course, disclosed to everybody, and that's, we got back to the team. But, sometimes you don't have time. If they come to you with an immediate problem, and depending on how it plays out, you may have to take a practical solution. And of course, the team agreed that, since the person was in treatment, that there was no way that we could proceed. And mind you, the person in the treatment facility was writing, requesting that we continue the negotiations to wrap the case up as soon as possible. We're like, no, we're happy to wait for you. And it was to her benefit.
Clearly that has to be, and that goes with the whole teamwork approach to this type of a divorce. The team needs to be unified and working together towards, a common decision in terms of what everyone feels would be best.
Let me throw out a couple of questions from a legal standpoint, or at least make a point. There is a difference in the confidentiality before the participation agreement is signed by everybody and after the participation agreement is signed by everybody. That's under 1.4. And if you, Aline, as you mentioned, would like to see the clients before the participation agreement is signed, perhaps, you need to look at 1.4b and the limitations that may exist in connection with the confidentiality. As a lawyer, I will generally ask the mental health professional to delay in seeing the client until after everybody has signed the participation agreement. That way there's full confidentiality in.
Jeff, you muted yourself.
The next issue that you brought up is your discussion with the therapist for the client. And this would be under your professional rules and regulations, having nothing to do with the collaborative process and what can be discussed, what can be disclosed, and things of that nature. But whatever is discussed and disclosed, I would caution people that there is an obligation under 3.1, if you were to find things out from the therapist, even though the client has signed an agreement allowing the therapist to speak with you and you speak with the therapist, under 3.1a, it requires that full and affirmative disclosure of all material information be provided to the team, whether or not requested. So that could be a very slippery slope from my perspective as a lawyer if we were to bring in an outside therapist's information, and to what extent you as the MHP neutral would be able to disclose and not disclose and still keep within 3.1. And I'll leave it to you at that point to respond.
No, I see what you're saying, and I couldn't agree more with it. The reason that I usually see clients actually before even the participation agreement is signed is so that I have something to share. I have something to say in terms of bringing to the table. I agree that it is a kind of slippery slope in terms of their participation agreement, in terms of what to share and what not to share. On the other hand, regardless of that, if I do feel somebody is in danger, as you said in these 1.2 and 1.1, our professional obligation remains to keep the client safe and do what it takes to keep them safe, whatever that means. If it means calling the police, if it means making sure the family member takes them to a hospital to get evaluated, those kinds of things. But yes, it could be a slippery slope in terms of what to share and what not before the participation agreement is signed. Although I will say that I do have the clients on my coaching contract, when they sign my coaching contract, agree that they will allow me to talk to, and it's the team members' names on there. So it's, again, it's kind of a situation. No, perhaps the participation agreement has not yet been signed, but yet they've signed a release allowing kind of a conversation to be had, because that even happens in a pre-brief prior to a first team meeting, technically. They haven't signed a participation agreement yet at that point.
And Aline, I would presume that your professional ethics, aside and apart from the collaborative ethics, will take priority over the collaborative ethics if push comes to shove, because you have to respect your professional ethics, as we all do.
Absolutely. Yeah. And again, if somebody's safety is being compromised, if they're talking about harming themselves in any way, that is something that really has to be addressed clearly, immediately, And there are, and let me just say that there could be a difference of opinion in terms of, oh, I'm not sure how serious she is, or I don't know, if she has a history of this, or maybe she doesn't have a history. There's no conversation to be had when anything like this has to be taken very seriously and followed up on, and not kind of debated. There's something that has to be done. You can tell I feel a little strongly about it.
As you should.
I agree. As a fellow MHP, I agree. So I'm wondering, just posing this to all the panelists, who makes the call if we feel that a client is unable to effectively participate in the process? Who makes that decision?
I think it's a team decision. I don't think it's any one person. I think we have to consider, especially what the mental health professional brings to the table in connection with that client, because they are probably most versed in being able to dissect the seriousness of the situation. Certainly much more than I as a lawyer would be able to. But I think it has to be a team decision, and this is the team work that is required under the minimum standards, okay? Which, and I can tell you personally, number one, I will not get involved in a collaborative process without a mental health professional involved, period. I just refuse to do so. You are essential to the process. As far as a financial neutral, if we're dealing with two W-2 employees and there really isn't anything that needs to be evaluated, you could possibly do without the financial professional. But I have also found that the financial professional who is schooled in the collaborative process is very, very helpful in formulating resolutions at the table. And because they can sit back and they can observe, and they're not in an advocacy position, but they're in a resolution seat where they can bring that to the table to help everybody come to the resolution.
I think the other thing is the challenge if you've got somebody that's not, I'm going to say, emotionally as ready as the other person to participate in the process, that there always is a risk that you end up either leaving your neutrality on the table or making statements that lean towards an advocacy position that you shouldn't be making as a neutral. So you're going to ask questions, you're going to ask people to the alternatives, but ultimately it's got to be the choice of the parties. So I also worry about those types of individuals that either don't have the education, which they should have by the time they're going to sit down, or the emotional fortitude to be able to speak with their voice at the table, because then all of a sudden the team has to shift to provide more in the sandbox for that to occur. And while we will do that within certain limitations, we can't do that to the point that it makes the other person feel like we're bending over backwards, because then there isn't neutrality and it's not an even playing field.
Well, and don't forget too, that the client always has the option also to come forward and say, I'm just not ready to move forward with this right now. I need to take a pause for a period of time. Can we do that? And that obviously would be respected as well.
Yes.
I'm thinking of just a retreat we did with our local practice group, and having that conversation of, even if the financial picture looks fairly simple, there may be a lot more to it, just given, again, some of those disparities in their grief and their knowledge of the finances. So just the value that having someone who is neutral around the finances can bring to the team.
It certainly, Melissa, becomes an issue if the finances are simple, but their spending is complex, and one of the parties hasn't accepted that they really don't have the money they're spending. And there needs to be somebody that says, I'm sorry, but it's just not here. That to me is one of the best roles that gets played because it's an independent.
So backing us up just a little bit around the potential risk and safety of wife in this particular scenario, and making the call as to if she's prepared to participate in the process or not, how would, and this goes to all the panelists, how would that be communicated to the husband in this family?
Well, I will say, just as a caveat, that this is based on a true case. Not all of the details. The details are protecting the innocent or whatever. Some of the details are different. I will say, in this particular case, the wife did say these comments during a team meeting, so everybody was well aware of it, and there was no surprise. On the other hand, if it had been done in a private coaching session, yes, there are certain confidentiality issues that come to the forefront in terms of that. But I think, again, it really depends on how severe her safety issues are. In other words, how in this kind of a situation, again, it's kind of not a clear situation because, again, it's if this happens, but the if has not happened at this point, then this is what I think about it. So at that point, I would not tell the husband about it per se. But if I felt she was much more of an imminent risk, then I think that the confidentiality would have to be breached. How do you feel about that, Melissa, being another MHP?
I tend to agree. I mean, I think if it happens in a team meeting, obviously that information is out there. But I think I would, as a default, always kind of take it back to the professional team and put our heads together and just think strategically, as well as ethically, what makes the most sense given the variables, and try to make that decision collectively so that we're all kind of stepping forward together to support the family and create that safety.
Well, and being a neutral is kind of a difficult situation in a case like this because it really, there are such concerns about one of the clients that kind of make you go in a certain direction, but you have no choice other than to do that.
Yep. As a lawyer, I have a responsibility. That's under 3.2 of our standards and ethics. It's also under the rules regulating the Florida bar, which I am required to follow as a licensed practitioner in the state of Florida. And I would assume most lawyers have that obligation wherever they are licensed to practice. Under 3.3, however, we have a provision for good faith negotiation. I have litigated for over 45 years of my practice. I've been a trial lawyer. And as a trial lawyer, we have been schooled in the win-lose paradigm of what we do on behalf of our clients. As a collaborative lawyer, we need to make the shift. Everybody talks about that paradigm shift for the trial lawyers and whether we're successful in doing so. And I will honestly say I've been called out on a few occasions where maybe I've advocated too strongly for the client, and I've been accused of not completing the paradigm shift. And I accept that. But in the collaborative process, the process is not based on winners and losers. It's an entirely different system than we have in litigation. If people want winners and losers, they can litigate. And they're all losers when they litigate. We all know that when it comes to family law. However, in the process, utilizing the theory under good faith negotiations, there would have to be an explanation to the client that we need to make sure, number one, that the wife is competent in moving forward in connection with the negotiations as it relates to the team proceeding and whether we need a timeout, whether something has to be done in order to protect the wife more so than normally. These have to be explained to the spouse because at the end of the day, we want to make certain that an agreement is fair and reasonable and it protects both people. Because if you wind up with an unfair agreement where it's totally one-sided, there's going to be a question under circumstances of this nature. Was the wife competent in the negotiations? Was she able to fully understand and appreciate her legal, not just responsibilities, but her legal benefits that she would normally have? And even though we're in an interest-based negotiation, it still has to be fair. And this is where 3.3 comes in. And it's the responsibility of the lawyer at the same time as advocating for the client to understand that the advocacy must be under good faith, under a good faith basis.
So that takes me to another question for the panelists. The husband in this case is anticipating and indicating that 90% of the assets will be his based on him being the higher earner. And then we're talking about at a team meeting where the attorney is speaking for him. And so I guess I'm interested in the panelists' thoughts on how that would be navigated, particularly perhaps during a debrief. If we're seeing that dynamic sort of show up around the husband's interest and that being a little bit imbalanced as well.
Well, first of all, under 3.2b, as a collaborative professional, as the attorney, we need to assist the client in advocating on behalf of the client, but we have to establish realistic expectations. And we can't expect that things are going to be so one-sided if, in fact, that's not what the law is going to allow to occur. So as the husband's lawyer, I would have to sit down with him and say, you know, it may be nice to think that way, but it's not realistic. And it's not fair. And that's just not the way life works in connection with a divorce. Now, in connection with me speaking on behalf of the client at all times, that is an absolute mistake. And it was a mistake that I made in one of my first cases that I had as a collaborative lawyer, as a matter of fact. I represented a woman who said, I can't stand up to my husband. I need for you to speak for me. And it wasn't until I was about halfway through the process that I realized what a mistake this was on my part in not having her have a voice at the table. This process belongs to our clients, and they need to speak up, and they need to have their interests known. And the beauty of the process is mediation, where a mediator will play shuttle diplomacy in two separate rooms, and the parties may never see each other. This gives an opportunity for each party to see and listen to what the other party is talking about and why they're asking for certain things and why they're taking a position that they may have, whether it be connection with children or finances or anything of that nature. And that's the beauty of the process. So we need to have the client speak for themselves as much as possible.
Well, and I think that goes to the standards in terms of 2.3, which is effective participation in the process. But it also goes to 3.2e, professionals will avoid contributing to the interpersonal conflict. And I think part of that happens when somebody is speaking for a client versus them speaking for themselves. And I find in coaching that that's a lot of what I do. A lot of people feel less than. They don't feel that their voice really matters as much as the other person's voice for various reasons, whatever their history has been. And to get them to realize that they are an equal partner in this process, and that their voice is equally important to the other person's, and it's critical for them to speak up.
I've role played with clients in a coaching type session like that, where it's ahead of the discussion on finances, allowing that person to educate themselves on how they do need to speak and how they need to talk about what's important to them, and to practice, expected responses from the other person, so that they get comfortable with the script, so that they can walk in the door and do it. Because once they start down that path of realizing that they do have a voice and have the ability to do it, the narrative in those discussions and in future discussions are very different.
Stu would say that's where we create and kind of hold that higher space for our clients and let it sort of evolve in creating those conditions professionally for them, for that to come out. So I'm curious, Marta, just as a financial neutral, with the wife sort of wanting to be done and get on, which often indicates to me as an MHP, it's kind of like stop the pain. But
Fatigue,
not so
deal
much
fatigue, as I call it, yes.
Right. How would you navigate that as the financial neutral, with her sort of being, potentially willing to give up assets that she might otherwise obtain, just to get it done?
So I start to place myself in a hypothetical situation, because I want to keep myself in check to avoid saying, what are you, nuts? Because that then all of a sudden imposes my value system into the process. On the other hand, I also feel professional responsibility to point out the financial risks and weaknesses to the approach that the person is taking, particularly when they're giving up things at the table that they have no backstop on. And so, with others present, including her lawyer, including the mental health professional, I walk them through the questions, and I say, hypothetically, if somebody were to come to me with this type of a situation and ask me my opinion, I would say that you're not getting the best possible deal that you can because of these factors. And you have to weigh those in terms of what's the choice for you. And if the person insists they want my quote unquote approval or rating, I have to say to them, love you, but this is not how it works. I'm the neutral. I'm not here to judge you or to grade you, but you do need to be, your approach comes with potentially insurmountable risks that can cause you harm in the future. And you need to be able to think about those and accept that those risks are okay if they happen. And that's about as far as I can go. And then I leave the room and drink coffee,
Martha,
because it's very frustrating. Yes.
Martha, would you bring the lawyer for the wife in as well and have a conference with the two of them?
Oh, no, I would not have that session without having the lawyer there and the mental health professional. And the reason I feel that way is because two things. I want to go on record that there's a team of people helping her through that thought process. Number two, I would want the lawyer to understand every issue I have, which I'm sure they do. I mean, in this one case, the lawyer was sitting back, shaking his head going, don't do this. And I'm like, I can't, that's not my role here to judge what the person wants. But I can't also, say that this is the best thing since right, because of these 6 reasons that you really need to consider. And in certain cases, I've had problems with individuals that would be indigent, but for the benefits at the table, that they are so, that they're so easily willing to give up. And at one point after the discussion we had, I said, maybe one of the options to get the person to process what we're telling her is to slow down resolution. Because what you would hate to have happen is that this is all about the rush to the finish line and the rush and the rush and the rush. And all of a sudden the person says, oh, I'll just give it. And then turns around and says, why didn't you stop me? So I know that the lawyer went back. We did put in a literal extra couple of weeks, which was not what we would have done. And that person still wanted to come to that alternative at the end of the process. Well, the other party was and there was nothing we could do about it. But we create opportunity to see what the risks were.
I think that goes back to this
But
advocacy.
there was a situation of, I would, part of the, I'm sorry, I don't mean, yes.
No, I was just going to say part of
There
it
was
goes back to,
definite deal fatigue and the fact that
goes back to the advocacy in the process 3.2 A through E about respecting the client's self-determination, and that they're responsible for making the decisions, but also their effective participation in the process 2.3, if they really can participate effectively in the process.
Melissa, can I just jump in for a second? Because
Sure.
I think there's something that's very important here. And I'm pointing out the husband is not being entirely forthcoming in terms of voluntarily providing all of the necessary financial information. It's a lawyer's responsibility under 3.10A to discuss with the client that it may cause the attorney to resign from representing that client if the client is not going to be honest and forthcoming with all of the information that is necessary and material to the process. You can't be complicit with your client in holding back information. It's against your own personal ethics, and it's against the ethics of the collaborative process. And under 3.10, if you find out that the client is not being forthcoming and is refusing to be forthcoming, you may very well have to resign.
And the team might resign as well,
in
not
fact, so
just
that
you.
we did that as a team in one case where we found that the husband was flat out, it was not only refusing, but taunting the wife in collaborative meetings to say, catch the errors if you can, or the omissions, which humiliated her, which I don't blame her, and put us in a position to say, if you were going to play chicken in that process, that's not what this collaborative process is about. And so we all did. We all resigned.
We did that on a case early
sorry.
on as well. And I was just thinking earlier, Jeff, you were sharing just one of the lessons learned early on in one of your cases. And I think that's where we really, it's really from some of those, you know, mistakes, if you will, that we make, that we learn some of the most valuable lessons, and the value, I think, of what we're trying to speak to today, really supporting each other and communicating through what we need to as professionals in order to support our clients through this process.
Can I just
So I
throw
know
out
we're-
one? Yeah, I'd like to throw out one last thing that's very, very important. I
Sure.
have created a toolbox for myself. In the toolbox has the standards and ethics. It has the Florida standards and ethics as well, because I practice in Florida. It has the statutes under which collaborative law is governed under Florida law, and the rule that the Supreme Court passed for collaborative process. And everybody should have that in their own jurisdictions, whatever is pertinent to them, their practice, their profession, their ethics. They should have it handy so that when you're in a team meeting and the question comes up, look it up. This is not rocket science. I mean, really, it's all there in black and white. There may be some interpretations, but it's really in black and white. Have it available at all times when you're meeting with the team, so that if a question does arise, you can cite right to chapter verse, as Aline has done throughout this, which has been excellent, to provide the backbone and the basis for why you are taking a position of the nature that you're taking on an ethical basis, not being positionally positional in the process itself. I just
Right,
wanted to throw that out.
I agree.
Sure.
I think that's a
I know
great
we've-
thing.
I know we've done that just even with clients kind of backdropping to the participation agreement when we're getting sort of lost in the emotion or the dynamics, and the risk of professionals even personalizing some of those conversations, that we just kind of center ourselves back on the purpose and intention of the process as well as standards and ethics. So I appreciate everyone joining us and the time of the participants in volunteering to be a part of this webinar. I know we're going to open now for about 15 minutes of live Q&A, and so this will wrap the recorded portion of the webinar up. And again, thank you everyone for your time and participation.
Okay, we will now have our presenters come up live to take questions. And I understand, presenters, you're going to pull your questions out of chat. So if people have questions, please put them into the chat. If they are in Portuguese or Italian, we will be able to get them interpreted. We'll just may need a minute. And speakers, if you need any questions, if you need me to pass on any questions, just let me know.
No, I think the question that is up in the chat right now is a very good one, which is that the clients, whether the clients can jointly agree to do what they want as long as they understand the consequences of their decision. And I think that certainly informed consent regarding those consequences is up to them. But I think you do need to have the discussion of what informed consent is and what the implications are of both sides of the choices that they have to make. And I don't know if Jeff or Elaine want to make any more comments on that.
I think the beauty of collaborative is the fact that clients are talking to each other and figuring it out. But I think there are certain parameters. And again, I'm not a lawyer. I can't say, I would refer this back to the attorneys. What will a judge allow and not a judge allow, or what won't the judge allow? And I can't answer that. And I would never even talk to clients about that. But that would be my question in this. What would a judge allow to happen? Again, if they're kind of outside, very outside of the parameters.
As an attorney, I would stay away from what a judge would allow and a judge would not allow, quite frankly, because we want to keep within the process and stay away from litigation implications. But one of the fundamental things that everybody should look at is 3.4, professional teamwork. The team is such an essential part of the entire process. And it's the team that is going to carry us through to a successful resolution more than anything else. And I have found in my experience that when the clients attempt to pit team members against each other, it becomes calamitous and it creates a major league problem. So the team needs to stick together. They need to be as one in a thought process, so to speak, and make sure that they rein in the clients as necessary.
Ultimately, clients that are impassioned about what they want to do, and you try to understand the motivations so that you can address not only the practical implications, but if they're operating out of a place of fear or frustration, that's why I made the comment that sometimes slowing down the process is a positive thing, because you give them the opportunity to reflect and understand the various inputs that you're giving, but ultimately they get to make the call. We do have a question here that I believe I understand it, but I'd feel better if somebody translated it out of Portuguese.
Okay, if we'll just wait a minute, our translators will translate and I'll be able to pass the question on to everyone. So just stay on the channel that you're on.
Just to get back while we're waiting, just to get back to this particular situation, people often come in with very fixed positions. And in this case, that would be a very fixed position. And I think, Marta, you were right in terms of what's really underneath that, getting to their goals and interests and talking about what those are. But then we also have to assess if this person is really stuck on those positions and is just not going to budge, or if we're going to get deeper and they're, going to realize more what's involved and have more of a realization of what's happening.
Okay, if we could just pause for a second, I should be able to hear the translation and I can pass on the question. It's in the bottom of chat right now. Yes. Okay, the question is, the question of betrayal hasn't been addressed here. And could this be affecting the wife's, I'm missing some of the translation, but could it be affecting the wife's assessment of how she wants to handle the situation, what she's willing to give up?
Many people come with lots of reasons that they say yes or no. Sometimes they're going to be open with the team members about their rationale. Sometimes they'll tell you that it's one emotion when logically the team thinks they may be functioning from a different perspective. But we try to drive the decisions based on information, less on emotions, so that they're making logic-based decisions. But you can't totally pull the emotion out of the equation for sure.
Well, and certainly as the coach, that would be a prime example of something that we would be working on with a client, because obviously a big part of our role is to teach people constructive ways of dealing with their feelings, and also teaching them constructive communication skills in terms of moving forward. I mean, these people had 3 young children. They're going to have to co-parent for a long time. And so talking to him about venting his extreme rage. Clearly there were emotional or challenges in the marriage prior, but the affair was the last straw. So we're going to allow him to have a safe place to vent privately in coaching sessions. And his anger is triggering her as well. When somebody's always coming at you with anger, and anger kind of makes you angry at the same time, and talking to her as well about trying to not only understand her own feelings, but trying to figure out where he's coming from and have a better understanding. And then also educating both of them on the impact of the divorce on their children, and figuring out how that they can get along in a good enough way to co-parent their children.
I mean, I think people think that collaborative means that it's a peaceful, happy divorce process to some extent. And while that would be wonderful, it's not that, or you wouldn't need 4 people sitting at the table to make sure that the process worked effectively. But, definitely this is where the mental health professional is, so significant that you can't quantify that benefit, because they will help make sure that at least the communication is heard and sent.
Yeah,
Okay.
it's not a walk in the park, people. It takes a lot of skill to get a positive resolution. And again, Eileen, what you said is one of the reasons I don't want to enter into a collaborative process without the MHP or coach, however they're referred to in the particular jurisdictions available. Because not only do you help the clients, you really help the lawyers as well, because sometimes, we get out of hand, and you can tone things down from our perspective in advocating on behalf of our clients.
Well,
Okay.
and just another aside on that, I'm also actually preparing to present at a basic training in our area in the future. And another part of the coaching role is kind of keeping the team on track. And again, you mentioned earlier, Jeff, about the paradigm shifts. And in all of the disciplines, some people are more and less successful in terms of achieving that goal, making that paradigm shift. And so we're also there to help with that as well, keeping the team on track in addition to the clients on track.
Okay, so we're going to have to jump in and wrap up because we're at the end of the hour, and I know many of our folks have to go. I want to say many, many thanks to our speakers, the members of our Standards and Ethics Committee. This has been incredibly enlightening, and it's especially been a treat to be able to have our interpreters present, so thank you to them as well. I know we're still, all of us, learning how to use this interpretation on Zoom, but it continues to get better and easier, and it's a wonderful opportunity to build more of our international community. So thank you, and thank you to the attendees for coming and for your patience. I just want to quickly preview a couple of upcoming IACP events. In July, our July webinar is going to be Access to Collaborative equals Access to Justice. And that will be on Wednesday, July 14th at 8 a.m. Pacific time. And we're going to have members of the IACP Access to Collaboration Committee discussing how people around the world are working to make collaborative practice more accessible. And then Forum is coming up on October 28th to 31st in San Diego, and also part of the program virtually. So registration just opened yesterday, and please visit collaborativepractice.com to learn more and to register and to get early bird pricing, as well as for the in-person forum, as well as for our virtual program that we're calling Beacon when we're apart. And please continue to check collaborativepractice.com and your emails for more information. And thank you very much, everyone, for joining us today, and we'll see you again soon.